Sarah Ordiah. I am a licensed attorney an attorney licensed to practice in Nigeria. After graduation, I decided to delve into technology law, and since then, I have garnered experience in data protection, in technology as a whole, contract drafting, and currently I am um, the lead for legal operations at Get Equity Limited.
So can you just share your own understanding of data privacy law in Nigeria as a whole?
Okay, not to be too controversial, but if you ask me to um, define data privacy law in Nigeria in one word, it would be lousy because it's everywhere. It's confusing even to the experts and to the. I wouldn't say the law itself as it exists is confusing to the experts, but I would say the implementation of those laws. I can give an example. Recently, the Nigerian Data Protection Bureau was created basically by no acts of the federal government. It was just created. And before then, there used to be regulatory filings that used to go to NITSA. And now filings are due in June. Until now, people don't know who they're supposed to file to. Do we file to NDBP? Do we file to NITSDA? If you reach out to either of the committees, you don't get an answer. You don't know what to do. So I think that for a country, stuff like that shouldn't happen. And aside that, I would say that privacy isn't really a thing in Nigeria because, first of all, Nigerians are not educated on how sensitive their data is. I personally feel like data is the new oil because there are a lot of, like, even the most profitable Fortune 500 businesses, their money actually comes from their processing of data. So data is actually an enriching substance. So if you're making money off of me, I think that at some point I should be able to control my data that you're using and be able to ascertain that that data that you're using is used properly and for the functions that you say is going to be used for. And I think that when it comes to that monitoring, we really don't have things like that in Nigeria. Yeah, the agencies try their best. They ask that audits be done for companies that have more than, I think, 1,000 1,000 data users. Those are supposed to make filings twice a year, I think June and December. But what I don't understand is how do you make sure that there are, how do you know companies that file more than 1,000? How do you know companies that file less? If you are supposed to enforce it, how do you know who is not doing it and how do you know who is doing it? So that kind of structure that hasn't been put together is why I describe Nigerian privacy law as lousy, especially in the part of implementation.
Always been interested in technology, and there's a very huge problem that we have, in the technology space, which is as regards, how lawyers and technology or technology professionals or let's say technologists, how they communicate. So it's been very difficult for lawyers to understand the needs of those technology professionals, and the technology professionals also understanding the legal requirements that they need to put in place, especially in terms of their product development and everything. So that's actually what led me to being very familiar with the technology space, different technologies, including software development, cloud computing, blockchain, and a lot of them. So I don't limit myself to just knowing the technology concepts, but also using those technologies. There was a time I was actually coding smart contracts, so I build websites, and then I also do a lot of things regarding cloud computing as well, and then I'm a cybersecurity person as well. So That's how I got to to my current role as.
But the regulations actually state what you should do and what you shouldn't do. The guidelines basically shows you the process on how you should do what you're supposed to be doing, especially for data processors and data controllers. I also think there's a data protection bill in the National Assembly right now. I think it passed the third stage recently. I read the bill. I still don't like it because aside drafting, Nigeria has big enforcement issues. And the problem I talked about just now, the whole tirade between NITDA and NDPB, it didn't actually solve the problem. So, and usually when laws are supposed to pass in National Assembly, there's supposed to be a public hearing where people who are experts in the field are supposed to have discussions and put, I think this shouldn't be here, that shouldn't be here. They didn't allow that go through that public hearing. So I'm not confident on the quality of the bill, because if experts don't critique it, it means that the people, the draftsman, isn't hearing things that happen in the business. And it worries me that things like that happen, because on one end, you have organs of government like CBN saying they want to start regulating new novel ideas like open banking.
Ordinarily, I always say that privacy is in an organization is actually a shared responsibility. It's the responsibility of everyone every employee in an organization. So it's not just if you have a data protection officer, or you have a chief privacy officer, or someone that is in charge of privacy issues or matters. That should be the only person that's that will kind of lead the privacy initiative. But then you need to start with a kind of culture, having a company culture where you respect privacy, and that is actually one of the principles of privacy by design. It has 7 principles as well, just as the data protection principles has I think 6 principles. So you need to look at those principles and then try to embed them, try to implement them in your privacy program. Okay, so the privacy program is going to have different policies. She has mentioned some policies that you really need to have, or some documentation that you need to have. So I don't just want to go into those. Maybe I'll list some of them, then I'll probably share how you could actually implement some of them. So we have the PIA, the Privacy Impact Assessment, or Data Protection Impact Assessments. We have the data retention document that shows that this type of data you need to. This is the timeline, or this is the time frame that you could retain those kind of data, just to. And then aside that, you also need to have data subjects. We have something called data subjects rights, and that's really has to do with privacy itself, because just as Sarah has defined privacy, that it is the giving control to the data subjects, how they can how you can interact or use their data. So you need to have those processes that, how do you do all these things? How do you ensure that they are properly done and they are, efficiently, done? And so the first thing should be the privacy program, ensuring that, and to make it easy, because you could say that, where do you want to start with the privacy program? We have different frameworks, international frameworks. We have the ISO, the International Standardization of Organization for Standardization, the ISO, and the NIST, the National Institute for Standards and Technology. They recently published some of the standards that you can actually use for privacy practices or data practices in your organization. So you could, it's for global purposes. But then, of course, you need to have, for organizations processing, 1,000 data, 1,000, processing the data of 1,000 people or more than 1,000 people. So I think there's a requirement in the Nigeria Data Protection Regulation that they need to have a data protection. They need to file, yes, and they need to have it's actually different. They need to file with the NDPB, the Nigeria Data Protection Bureau, and though there are some requirements, you need to approach a data protection compliance organization for that and everything. Though I have a bit of an issue with just the because it's a kind of checklist. They were asking you a question. I don't think any organization in its right sense would say that they're going to say, they don't have this. So it needs that, it's a kind of auditing, but then it's not done well. That is not how so many cybersecurity standards have been operated, like SOC, like the ISO auditing and everything like that. So we need to really do better in that regard of auditing data practices of an organization.
Data. Say, I don't want to give you this data again. Today, I want to collect my data back. Can you delete my data? So that's like the whole ambit of privacy, putting control of their information in the hands of the users. But open banking is a procedure to use the data from data privacy. So it is easy to create ideas from that, because at the end of the day, open banking simply is a process. It's not an idea. Or would I call it an idea? It's not like an ideal. It's a process. So if we want to rally around privacy and data, because at the end of the day, data should be like constitutional rights. I know that in the Constitution, there's something about private family life, but it is not what we should have in the Constitution. Data is a fundamental, like data privacy is a fundamental human right, but the way it's couched in the Nigerian Constitution can mean, okay, we'll have, and I don't know, I'm very uncomfortable with it being called private and family life. It makes it sound very simple. It doesn't have the complexity that data is today. So why I feel like you cannot really adjudicate privacy the way you do open banking is privacy is wider, more complex, and the consequences of failing in it could affect open banking. I think there are stakeholders that are interested in changing like what privacy is in Nigeria. But one thing you have to understand with communicating with regulators, it's a very, very unpredictable game, because at the end of the day, most stakeholders that are very interested in data privacy in Nigeria come from a very different generation. Not to sound stereotypical, most of them are Gen Z people, and they would not be able to have like the psychological arrangements to talk to many people who are like heads of departments when it comes to like making foundations for data, because most people there are like boomers and millennials that are very, very on respect and approach and things of that nature. So, and I think that's why a lot of people, especially people who are stakeholders, like long age angel investors, they really support like lobbying with people in House of Reps, people in the Senate, people. And I was really surprised that in this election cycle, I didn't see like having like a tech company sponsor somebody's campaign, going to the National Assembly or going to the House of Representatives. That is gerrymandering. And that is a way that you could make sure that like setting, like first of all, something like the Startup Act. I know that stakeholders were like involved in the draft of it, but I think, yeah, it's good as a start, but there are people like me who I don't believe, like right now, is there any startup that has startup certificate? No, because when they thought about putting it into law, they didn't think so much about the implementation. Is there an office that you go to and you can register? No, it doesn't exist yet. There was just the buzz of it. Oh, we're creating a startup act so that business. But if you sponsor people to the National Assembly and sponsor people the House of Representatives, and these people put bill after bill, and you are the one that's going to give them the bill, they don't necessarily have to draft it.
If you're sponsoring, are you not making a party?
That's the thing. Ideas like data privacy, and because the Nigerian political space is quite different from what we have outside Nigeria. If you were in the US, it's going to be harder because the beliefs around being democratic and Republican, there are like philosophies when it comes to data. Republicans don't want so much data exposure. Democrats feel like you can expose those data, but there should be like regulations around it. Like if you want to scare Republican, tell them that Russians are stealing their data, and you see that they'll fidget and all. But in Nigeria, nobody cares about that. People don't even know about data. And at the end of the day, the people who it is important to are those stakeholders, because they are the ones who need to process data. Maybe there will come a time when Nigerians are more, younger people, they are more sensitive about their data, but the kind of data that they're sensitive about are like personal data that has to do with business, data that these companies actually need. Nobody cares about them. So when it comes to sponsoring these people, you don't need to have a specific party. You could just have a person approach them. Okay, we want to, what you need for your campaign or whatever. And when you get here, these are the bills that we want you to pass. Those bills can't kill anybody. And at the end of the day, they are going to be peer reviewed. They're going to go through many committee stages. And if there are anything that is wrong, they'll be thrown out. So personally, I was really surprised that we didn't see, especially how controversial the electoral cycle was. I'm very surprised we didn't see these kind of conversations, because if we want to change the face of data privacy in Nigeria, it seems like people who are elected into public offices are, as is, supposed to know these things. But at the end of the day, we can't take it away from them that these things are not important to them.